passed on 17th of October 24 do not meet the threshold for impeachment set out under Article 150 as read with Article 145 of the Constitution. Hence, the same B regarding Gachagua, EGH, Deputy President, Republic of Kenya. At the ninth prayer, the petitioner sought an order of certiorari to bring up into this court to be quashed the resolution of the Senate of Kenya made on 17th of October 2024 to remove from office by impeachment His Excellency Rigathi Gachagua, EGH Deputy President, Republic of Kenya, on the grounds expressed in Gazette Notice number 13-400. He also sought at prayer number 11 a declaration does issue that the IEBC could not clear Kithure Kindiki without the involvement or approval of commissioners under Article 88 and Article 250 sub-Article 1 of the Constitution as read with Section 4 and Section 11A of the IEBC Act. The purported clearance was therefore null and void. Further, the overnight clearance violated Article 10 of the Constitution on openness and transparency. At prayer number 12, His Excellency sought a declaration does issue that Kithure Kindiki is disqualified under Article 10 and 72 of the Constitution due to unresolved concerns from his tenure as Cabinet Secretary for the Interior and National Administration, during which Kenya endured gross violation of human rights. He also sought a declaration does issue that the National Assembly violated Articles 124 sub-Article 4 and Article 149 sub-Article 1, Section 6 of the Public Appointments Parliamentary Approval Act, Cap 7F, and Standing Order 45 in the method it adopted to approve Kithure Kindiki's nomination as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and procedurally cleared and unlawfully approved as nominee for Deputy President in violation of Articles 1, Article 10, Article 8, Article 118, Article 124, Article 137, Article 148, Article 149, and Article 250 of the Constitution, so that his appointment, clearance, and approval for that position is null and void. At prayer 15, he sought a declaration that the petitioner suffered harm and is therefore entitled to constitutional damages as compensation for the violations against him in terms of general damages, punitive and aggravated damages, security to be specified at the hearing, special damages under Gazette Notice number 10346 of 2023 for loss of 1, salary, 2, official transport and other prevailing transport policy for 35 months, medical cover and benefits detailed to be supplied, airtime, gratuity, and annual salary for 5 years. He calculated those sums and gave the figures. At prayer number 16, His Excellency sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act, Chapter 197B of the Laws of Kenya, being a monthly pension equal to 80% of the first petitioner's last monthly salary while in office. 2, a lump sum payment on retirement calculated as a sum equal to 1 year's salary paid for each term served in office. 3, 2 saloon vehicles of an engine capacity not exceeding 2,000 cc, which shall be replaceable once every 4 years. 4, 1 4-wheel drive vehicle of an engine capacity not exceeding 3,000 cc, which shall be replaceable once every 4 years. 5, a fuel allowance equal to 15% of the current monthly salary of the office holder. 6, full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7, 2 drivers. 8, 1 personal assistant. 9, 1 accountant. 10, 1 secretary. 11, 2 housekeepers, 12, 2 senior support staff, 13, 2 cooks, 14, 2 gardeners, 15, 2 cleaners, 16, armed security guards, who shall be provided on the request of the first petitioner, 17, diplomatic passport for the first petitioner and his spouse, and 18, office and office equipment, 19, maintenance expense for the vehicles provided, 20, access to the VIP lounge 2 at all airports within Kenya. He also prayed for cost of this petition and such other reliefs as this court may deem just. In support of his claim, His Excellency Gachagua submitted, or rather in his submissions, he advanced his case further through written submissions dated 7th of October 2025, which were orally highlighted in court by his counsel, Paul Mute Senior Counsel, Elisha Ongoya Senior Counsel, and Mr. Ochiel Dudley, among others. The unifying premise of their submissions was that the impeachment proceedings were not purely political processes insulated from judicial scrutiny. Instead, they constituted constitutionally regulated proceedings subject to the supremacy of the Constitution, the doctrine of legality, and the supervisory jurisdiction of this court under Articles 23, 47, 50, and 165. Overall, they came up with the following issues for court's determination. 1, whether National Assembly motion met the constitutional threshold under Article 145. 2, whether the Senate violated Articles 145 sub-Article 3 to 6 by failing to appoint a special committee to investigate the charges. 3, whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the petitioner a fair hearing. D, whether there was adequate public participation at both the National Assembly and the Senate. E, whether the speakers of the National Assembly and Senate were biased in reality or in perception. F, whether the overnight clearance and approval of a replacement of Deputy President evidence a predetermined process. G, whether Standing Order number 62 sub order 2 of the National Assembly is valid. And then lastly, what are the available reliefs? The lawyers for His Excellency, the petitioner, Rigathi Gachagua, collectively submitted that while Parliament undeniably possesses the authority to undertake impeachment, such authority is neither absolute nor immune from judicial review when allegations of constitutional violations, irrationality, or procedural impropriety arise. They characterize the proceedings as a politically engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while deliberately undermining constitutional substance, thereby necessitating judicial intervention to preserve the rule of law. Leading the charge on the constitutional standards of the process, learned senior counsel Elisha Ongoya anchored his arguments on constitutionalism and legitimacy within Kenya's presidential order. He submitted that the Constitution transformed governance from unrestrained political discretion to a system founded on constitutional limitation and accountability, which rendered all exercise of public power, including parliamentary impeachment, subordinate to the Constitution and amenable to judicial scrutiny. Describing the proceedings as an exercise in malicious compliance, he drew parallels to the historical trials of Socrates, Sir Thomas More, and Jesus Christ to demonstrate how processes can appear outwardly lawful while being fundamentally unjust and predetermined. He maintained that constitutional democracy depends on good faith, adherence to fairness, and constitutional morality, not merely technical compliance. In analyzing the text of Article 145 and Article 150, Counsel noted that the threshold language, gross violation, gross misconduct, and serious reasons prove impeachment is a mechanism reserved strictly for the gravest constitutional transgressions. To that end, Counsel drew the support from the cases of Mike Sonko, which we have, particulars we have given, Muya and versus Tribunal appointed to investigate the conduct of Justice Martin Muya, we have given citation. He used these cases to argue that grounds must be substantiated by cogent evidence to an intermediate standard higher than a balance of probabilities. Senior Counsel Ngoya further submitted that since impeachment directly interferes with the sovereign will of the electorate expressed through universal suffrage, courts could not abdicate their responsibility by treating it as a purely political immune process. It was his case that the grave consequences of removal brought the matter squarely within the High Court's supervisory jurisdiction, requiring it to interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted on the democratic mandate and the political question doctrine. He was emphatic that impeachment in Kenya's presidential system is an extraordinary constitutional remedy of last resort. He distinguished Kenya's architecture from parliamentary systems where executive tenure relies on legislative confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate through universal suffrage and cannot be removed due to transient political dissatisfaction or partisan convenience. In view of the fact that impeachment effectively overturns the democratic will, it was Senior Counsel's position that the Constitution deliberately imposed strict procedures and substantive safeguards that courts are duty-bound to enforce. Learned Counsel drew support from the decision in Mike Sonko Mbuvi, which we have stated, to restate that the threshold for removal could not be reduced to political expediency. He further called to his aid the Court of Appeal decision in Martin Nyaga Wambora, we have given citation, to argue that judicial review of the proceedings affirmed constitutional supremacy rather than offend the concept of separation of powers. He firmly rejected the respondents' invocation of the political question doctrine, asserting that the Constitution creates no autonomous islands immune from accountability, and he maintained that all constitutional power remains subordinate to the judiciary's review. Learned Counsel Mr. Ochieng Dudley submitted on jurisdiction and the mandatory duty to adjudicate. At the outset, he pointed out an alleged internal contradiction in the respondent's case, simultaneously conceding the court's jurisdiction while urging it to abstain from exercising it. He submitted that constitutional adjudication could not be avoided simply because a dispute implicated political institutions or carried political consequences. He took the position that once allegations of procedural impropriety or rights infringements arose, the process ceased to be purely political. Drawing on the United States Supreme Court decision in Cohens versus Virginia, we've given citation, he argued that a court acts just as improperly when it declines constitutionally vested jurisdiction as when it arrogates jurisdiction it does not possess. It was his case that Article 165 imposes a mandatory obligation on the High Court to determine disputes whose constitutional violations are alleged as such. The judiciary would itself violate the Constitution by declining to hear politically sensitive questions. Mr. Ochieng submitted further that separation of powers does not establish institutional immunity and that judicial review ensures Parliament acts within its boundaries. Citing the Supreme Court advisory opinion in the matter of Kenya National Commission on Human Rights, Counsel concluded that constitutional interpretation in such disputes must be transformative, holistic, and purposive rather than mechanical. In the written submissions, His Excellency Gachagua specifically impugned Ground 8 of the charges, noting that it relied on Section 132 of the Penal Code, a provision already declared unconstitutional in Robert Alai versus the Attorney General matter. On the right to a fair hearing, he maintained that the Senate violated